Hello and welcome to TaxPundit.org. TaxPundit is India's most popular and trusted database of income tax case laws. In today's video, we will be analyzing a landmark case study that provides critical insights for tax professionals. Let's dive right into the details. The case under discussion is Joint Commissioner of Income Tax vs. Esmart Energy Solutions Limited, pronounced by Mumbai Tribunal on 7 May 2026. Smart Energy Solutions Limited filed its return for assessment year 2023-24 on 24 November 2023, declaring total income of Rs 17 crore, 94 lakh, 87,630 and opting for the lower tax rate of 22% under Section 115 bar. On the same date, it filed Form 10 IC. The due date under Section 139(1) was 31 October 2023. The CPC, while processing the return under Section 143(1), on 27 May 2024, denied the concessional rate citing delayed filing of Form 10 IC. The assessee's rectification application under Section 154 was rejected on 12 November 2024. On appeal, the CIT appeals directed the AO to recompute tax by granting the benefit under Section 115 bar, observing that Form 10 IC was available on the CPC portal and the denial appeared to be a technical error. The revenue appealed to the ITAT arguing that the option was not exercised within the prescribed time limit and that no condonation of delay was obtained under Section 119(2)(b). The tribunal noted that Form 10 IC was filed on 24 November 2023, after the due date but before the CPC processed the return on 27 May 2024. The intimation under Section 143(1) itself recorded that the assessee opted for Section 115BAA. The tribunal accepted the assessee's explanation that the delay was due to a change of auditors. It held that since the form was filed before processing and all other requirements were met, the benefit should not be denied on purely technical grounds. The revenue cited Bombay High Court in Rama Industries Limited vs. PCIT 3, arguing condonation must be sought under Section 119(2)(b). The tribunal distinguished this, noting the CIT appeals did not condone delay but directed the AO to consider the form already on record. The tribunal held that the CPC automated processing should not ignore information already uploaded on its portal. The intimation under Section 143(1) is a summary assessment, and if the taxpayer's option is clearly recorded, the AO must give effect to it unless there is a substantive defect. The ITAT dismissed the revenue's appeal and directed the AO to recompute tax liability by granting the benefit under Section 115 bar. The decision prioritizes substance over rigid deadlines, but is fact-specific. Question: what is the key takeaway from this ITAT decision? Answer: the ITAT held that the benefit of the lower tax rate under Section 115 bar cannot be denied solely because Form 10 IC was filed after the due date under Section 139(1), provided the form was filed before the CPC processed the return and all other conditions are met. The delay due to change of auditors was considered a valid reason. Question: does this ruling mean taxpayers can always file Form 10 IC late? Answer: no. The decision is fact-specific. The tribunal emphasized that the form was available on the CPC portal at the time of processing, and the revenue did not dispute any other condition. Taxpayers should still strive to file Form 10 IC by the due date to avoid litigation. Question: what was the revenue's main argument, and why was it rejected? Answer: the revenue argued that the option under Section 115 bar must be exercised before the due date under Section 139(1), and any delay requires condonation under Section 119(2)(b). The ITAT rejected this because the CIT appeals did not condone the delay but merely directed the AO to consider the form already on record. Question: how does this decision impact the CPC processing of returns? Answer: the CPC must consider Form 10 IC if it is available on its portal at the time of processing, even if filed late. The intimation under Section 143(1) should not ignore such forms unless there is a substantive defect. Question: can the revenue appeal this ITAT order to a higher court? Answer: yes, the revenue can file an appeal under Section 260A to the High Court if a substantial question of law arises. However, given the factual findings, the revenue may face an uphill battle. Question: what should taxpayers do if they face a similar delay? Answer: taxpayers should document the reasons for the delay, for example, change of auditors, and ensure Form 10 IC is filed before the return is processed. They should also be prepared to argue that the form was available on the CPC portal and all conditions were met. Thanks for watching this video. You can download the full legal analysis, the official case law, and a concise case digest PDF directly from our website, taxpundit.org. If you have any questions, feel free to write to us at taxpundit@taxpundit.org or message us on WhatsApp at 9326306668. Don't forget to subscribe to our channel for more authoritative legal updates.